Good morning, ladies and gentlemen. My name is Dmitry Feofanov, also known as ChicagoLemonLaw.com. I also respond to, hey, you come over here. And if anybody says vodka, I usually say where. So it's easy to address me the easy way rather than struggling with my last name. But apparently we are here to talk about lemon law, and I don't know whether you have access to it, but there is a cheat sheet that I prepared for today's lecture, which says cheat sheet for when you have a lemon case. If you memorize this page, you'll know 90% of what you need to know. And so everybody should keep that piece of paper. It's just one piece of paper, easy to memorize, because there I attempted to do something differently from the normal CLE presentations, where the speaker talks about certain things, and then there are course materials, which may or may not relate to what he's talking about. And so in my experience, when I used to listen to those things, usually nobody pays attention at the course materials, and they just go by wayside, never to be open again. That's not going to happen today, because we are going to go through this 4 times, and hopefully by the end of that presentation, most of it will remain in your heads, and if whatever you don't remember, you will be able to refer to if you keep that piece of paper, all important piece of paper. So without much further ado, we go into the subject of today's lecture presentation, which is what to do when somebody waltzes in the door of your office and it appears to be a lemon law case. So preliminarily, let me back up. There are basically 2 areas which arise all the time when you have quote unquote a lemon law case, a car case. And those areas are warranty law and fraud law. Those are the 2 basic areas. There are also various subsidiary things, such as also runs, subsection B. And that is federal alphabet soup and state lemon laws. Now, there are a bunch of federal laws that relate to car transactions, such as Truth in Lending, Equal Credit Opportunity Act. They are very technical, and I am not going to cover them today. They do exist. Sometimes they are useful. Like, for example, ECOA claims, they come into play when there is a technique known as a yo-yo, or as car dealers call it, spot delivery. That is when they bring the person in, then all of a sudden the financing doesn't get approved. That is a lie, by the way. And they bring them in and say, well, we need to have you sign a second contract. Or they just plain and simple say, bring in the car and we may or may not give you a down payment back. ECOA and local and state-specific unfair deceptive practices, UDAP, unfair deceptive acts and practices, come into play. But we're not going to cover them. Those are technical things, and they do not come up very often, or at least less often as the 2 basic areas, which is warranty and fraud. And so then there is another area which we're not going to cover, and that is state lemon laws. And the reason we're not covering them is because they're state-specific. Some lemon laws in some states are good. Some lemon laws in some states are, for the lack of better term lemons. For example, in my state, Illinois, our lemon law is a lemon for a very simple reason. It doesn't provide for attorney fees. So even if a person avails him or herself to a lemon law, they will have to pay a lawyer, and therefore whatever recovery they get would be correspondingly diminished. So it's a crappy remedy, and we in Illinois practically never use it. Plus, of course, the lemon laws, at least our lemon law, and most of them think they operate in terms of presumptions, and presumption, as you know, is something that can be rebutted. So they have this wonderful provision that 4 or more attempts during the 12 months or 18 months creates a presumption of nonconformity. Okay, great. You go to a hearing before the BBB in Arlington, Virginia, and then the manufacturer comes and rebuts the presumption, or the arbitrators allow them one more attempt to repair the car. It's a waste of time, most of the time. I do know that some people make nice living doing lemon law in some states, and it's a different type of practice, probably high volume, and they get paid $1,000 or $2,000, and if you have 100 of those, it's okay, but not in my state. Therefore, we get into the meat of the whole thing, and that is warranty and fraud. So, going back to the horrible first year of law school, Article 2, I'm sure some of you remember that. It is mostly Article 2 of the UCC as connected with the Federal Magnuson-Moss Warranty Act. So, going through my outline, the express and implied warranties under Magnuson-Moss. What is Magnuson-Moss? Let's get it out of the way to begin with. Magnuson-Moss is not much of a substantive law. It's a disclosure law. It's a disclosure law, and the subject dear to everybody's heart, it's an attorney fee shifting law. So Mag-Moss says that there are certain, first of all, it defines warranties, because warranties under Mag-Moss are different than warranties under the UCC. Warranties under the UCC is any statement of fact. Warranties under Mag-Moss, which relate to cars, is a promise to repair, in essence, in the first section of Mag-Moss. And so most car warranties, most manufacturers' warranties, and we're talking about express written warranties, they must be in writing, and they must make a promise to repair within a certain period of time. That's an express warranty, and Mag-Moss says that if you prove the express warranty, a breach of express warranty, you get paid by the defendant. That's the express warranty. And implied warranties, Mag-Moss does not define, but rather says whatever implied warranties you got refer to state law. So with respect to implied warranties of merchantability or fitness for a particular purpose, mostly it's merchantability. It's section 314 of Article 2, which defines implied warranties as fitness for ordinary purposes for which certain goods are made. In cases of cars, it's obviously going from point A to point B without killing you. And of course there are 6 definitions. Is it 6 or 7? I don't remember. One that is very often overlooked, is actually the first definition, because the fitness for ordinary purposes, with which some of you may be familiar because it's out of here, is only number 3. The first one is an interesting one. It's passing without objection in the trade under the contract description. Think about that. If you get a rebuilt wreck and it's not written in the contract, oh, by the way, we're selling you a rebuilt wreck connected with chewing gum in important parts. It's not the contract description of those goods. And I had multiple instances where people attempt to trade it in after some problems or whatever. And the dealer pulls a Carfax and says, well, it says here it wasn't an accident, we're not taking it. Well, that's not passing without a trade, without objection. So that is a breach of implied warranty. Why implied warranties are good as opposed to fraud, which is an obvious knee-jerk reaction of everybody, is because implied warranties don't have the bad intent requirement, doesn't have scienter requirement. It's basically like a strict liability law. In fact, there are cases that says implied warranties and strict liability are very, very much related, not even as close as cousins. They're pretty much the same. And therefore, for implied warranty, all you need to do is to show that the person who sold the car was a merchant of in those goods. First of all, that there were goods, as opposed to, say, real estate. Cars qualify. That the person who sold the goods is a merchant in cars. And number three, that it doesn't meet the test, either doesn't pass without objection in the trade under the contract description or is not fit for ordinary purposes. And that's it. No bad intent, no higher burden of proof, which is attended to any kind of fraud claim. So it's an easier claim, unless, of course, the implied warranty is disclaimed by expressions such as with all faults or the old proverbial as is. We assume it's not. If it is, then you fall back to your fraud claims. Anyway, the difficulty with the implied warranty claims is that under Section 725 of the UCC, it's a very counterintuitive claim. It has to be, you have to prove that the implied warranty is breached at the time of sale. It says right there in the statute. So when you get a car a month later or 6 months later or a year later with a problem, you have to somehow prove that the breach occurred on the day of sale. The longer it lingers, the more difficult it is to prove, obviously, but not impossible. At least in most states, as far as I know, you prove it by inference. And the inference consists of two elements. Number one, absence of abnormal use, and number two, absence of any reasonable secondary causes. Translated into English, absence of abnormal use. The client has to testify that he didn't drive it in the car in the Indianapolis 500, did not drag race it, drove it normal. We can infer then that whatever problem he's complaining about existed on the day of sale. Absence of reasonable secondary causes. In a fit of rage, did not go in the garage and hit the car with a hammer, or the tree did not fall in the car and damage it. No secondary causes. We can also infer that the problem existed at the time of sale. And MAGMOS, being a disclosure statute, also imposes particular additional requirements to any kind of warranty claims. And that is, under MAGMOS, as opposed to the UCC, we have to give the dealer a reasonable opportunity to repair, whatever that means. If they repair and fail, that's a reasonable opportunity. If they refuse to repair, that's a reasonable opportunity. Check if there is a reasonable opportunity that that element is met. Also, at least in express warranty claims, you have to be very, very careful in terms of reading the actual warranty booklet, because under MAGMOS, there is a non-binding arbitration requirement for suits against manufacturers for express warranty. Implied warranty against manufacturers depend on the state because of the privity problem. Some states allow it, some states don't. But express warranty, always allowed. But you have to go through a non-binding arbitration. And that is a jurisdictional requirement. If you don't do it, you're out. So MAGMOS requires a non-binding arbitration. They have 40 days to get their stuff done. It's a waste of time. It increases the costs. It usually does not result in anything. You just have to do it before you file. If you don't do it, they have a defense, and you will get kicked out. In some instances, they will stay the case and allow you to go through a non-binding arbitration. So standards of breach, easy to remember: reasonable time or reasonable number of attempts. In other words, if the warrantor repairs the goods within reasonable time or reasonable number of attempts, there is no breach. If they take unreasonable time or unreasonable number of attempts, there is a breach. What's reasonable? Your guess is as good as mine. 5 repair attempts are good. 5 repair orders are good. 10 is better. 15 is even better. 20 is gold. I once had a 25. The case settled. So the more the merrier. It reminds me of my wife, who always comes in and says, "Why do you always represent people who are alive? If you represented people who are dead, it will be an extra 0." There is a profound wisdom in her statement. The more they're hurt, the better the case. So people get hyper about those things. They think that after 3 repair attempts, they're entitled to return of their car. They're not. Those cases need to be prepared. The manufacturers need to be set up. The more the merrier. So that in a nutshell is the warranty prong of damages. Damages are determined by the UCC, sections 714 and 715. A normal item of damages in a warranty case is diminished value. The principle being, you buy a car, it's worth this much. With a hidden defect, it was worth only that much. This part is your damages. That is subject to expert testimony. I don't think it would be wise to have a client testify about that, because they're not in business of appraising cars. Therefore, you need to have a qualified appraiser who will be able to say that on a day of sale, we know what the value of the car is, that was the purchase price. But what we don't know is by how much the value was diminished because of whatever, faulty transmission. And that spread is their damages. Under the UCC, you can also get incidental and consequential damages under Section 715 of Article 2. But unfortunately, in most manufacturers' warranties, it is explicitly excluded. So unless you find a way to say that that exclusion was unconscionable, you probably won't get incidental and consequential damages. Now, which brings me to the second prong of the car case, fraud. And that would be your regular black letter common law fraud, or state UDAP statute, unfair deceptive acts and practices, if you have a good one. In some states, that is only a judge claim, so you don't get a jury for a consumer fraud, statutory fraud claim. But you most definitely get a jury for a common law fraud, either misrepresentation or concealment of material facts. What are the usual common factual scenarios? The plum, the low-hanging fruit, the case which everybody should grab would be a rebuilt wreck. Because those are bad. We're talking danger to limb and life. That is a punitive damages case, especially if they knew about the fact that the car was in a prior accident and rebuilt. The way to find out is to find out where the dealer bought the car, If it's an auction, there will be announcements about the car's condition. Sometimes they're very revealing. And unless there is very strong evidence that it was the problem was the car, the evidence of prior wreck was so obvious that it would be noticeable to anyone who is in business for more than a month. Those are punitive damages cases, and they should be pursued aggressively. Related to that would be, the misrepresentation of the car condition. Any kind of financial shenanigans with respect to finance contracts, too complicated, too technical, not sexy enough, probably should not bother. And of course, the real fun part of any kind of fraud case would be to go after punitive damages. And I think that in most states, the standard for punitive damages is pattern and practice evidence, i.e., whether or not the dealer did it to some other people. Now, under rules of evidence, you can't use pattern and practice evidence to prove liability, but you can use it to prove other things, such as modus operandi, knowledge of the condition, et cetera, In the rule, there is a listing, I think it's 406, and there is a listing of all the things that you could use pattern and practice evidence. Dealers would fight tooth and nail, defendants will fight tooth and nail against introduction of that evidence, because of course they know that in juries' minds, the distinction between proving liability and proving something else, like reprehensibility of conduct for purposes of punitive damages, the line between those two is blurry. And whether, even though with a proper jury instruction that no, you can't use it to prove liability, they still might, because if they're mad enough, they will be inclined to punish the defendant. So that is gold. And the question is how to get that gold. To get it from defendant in discovery, good luck to you, not going to happen. They're going to hide, they're going to lie. The best way I know of, maybe some people know better, is to start with a FOIA request to the state. At least here in Illinois, people complain to our Attorney General all the time. And so a FOIA request to Attorney General usually brings a file with a bunch of requests. The complaints should be roughly similar to the factual scenario in your case. And of course, because of privacy concerns, the Attorney General wipes out all the names and addresses. But if you get something that looks promising, then we go to a court and get a court order saying, Mr. Attorney General, please provide the names and addresses because we're going to use those people as witnesses. And with the right lineup of the cards, punitive damages. So I spent 23 minutes giving you a more or less outline of the claims. Now I'm going to go back and do it again because my objective in this exercise is to have you remember more than what you would remember after hearing it once. Because after hearing it once, you won't remember much of anything. You might be amused, but you won't remember. So we go back to the beginning and do it in a shorter version. When you have a lemon law case, you need to worry, generally speaking, about two areas of law, and that is warranty and fraud. Warranty cases involve two subsets: express warranties and implied warranties. Express warranties both of those are intertwined with the Magnuson-Moss Warranty Act. Magnuson-Moss Warranty Act is not a substantive statute. It provides for certain disclosure requirements and, most importantly, entitles anyone who wins a warranty case to be paid. Incidentally, I will add something which I did not mention the first time around. The MAG-MOS, I think it's the legislative history. Oh no, I'm sorry. It's actually in the act. It says, with respect to attorney fees, it says it has language that says something like based on the actual time expended. The reason that is important, and the reason that language is there, is because in your normal warranty case, your damages may be relatively modest, depending on how expensive the car is. Say it's a $10,000 car, diminished value may be $2, $3, $4 grand, 20, 30, 40%. But as all of you know, if you do a jury trial, it would take way more in attorney time than even the price of the car. In fact, it may very well be twice that much or 3 times that much. It all depends on how much resistance you get from your defendant. So you can imagine what happens. You can imagine what happens to you, or what would happen to you when you go before a judge on a fee petition in a $10,000 car with a $40,000 fee petition. The knee-jerk reaction of the judiciary would be, "You got to be kidding me," and the dreaded word proportionality comes in, and the judge would want you to get $2,000 in fees instead of 40. Happened, been there, done that. And so it's important to remember that based on the actual time expended is a recognition by the Congress of the United States that warranty cases are different cases and different principles involved, and therefore we're entitled to get paid. That is my aside regarding attorney fees, which come from Magnuson-Moss. But substantively, we're talking express warranties and implied warranties. And express warranties under the UCC are different than the definition of the express warranty that is given in the MAG-MOS. And the definition in the MAG-MOS is a promise to repair within a certain period of time. And I want you to remember that the standard for finding a breach of warranty, whether it's express or implied, is reasonable time or reasonable number of attempts. The magic words are reasonable time or reasonable number of attempts. If they fix the car within reasonable time or reasonable number of attempts, there is no breach. However, if they take their sweet time because the parts are not there, not my problem. Or as they say in Chicago, not my circus, not my monkey. Unreasonable time. That is a breach of warranty, and we're entitled to monetary damages, which are, in warranty cases, come from Section 714 and sometimes 715 of Article 2. The normal measure of damages in warranty cases is diminished value. That is, there is a difference between the car as represented and the car as it was with defects. That difference is diminished value. That is what they owe us. Sometimes, if you can make an unconscionability argument, you can get incidental and consequential damages, such as, for example, loss of use. If they keep the car for half a year and your client has to pay under the finance contract monthly $300-400, that's a very easily provable loss of use. That's express warranties found in the booklet of a manufacturer, and the two big caveats that one has to remember is, number one, you have to give them a reasonable opportunity to repair. Usually it's not a problem because usually people come to you after multiple repair attempts. So that's usually not an issue. The other big one, which sometimes people miss, is that under the MAGMOS, there is a requirement, and it would be listed in the warranty booklet. There would be a requirement of pre-suit, jurisdictional, non-binding arbitration. Binding arbitration is an entirely different matter. It's the Satan of consumer law. We hate it. We have to use it because the people in Washington would not do anything about it. But that's not part of the issue. The non-binding arbitration on the MAGMOS, they have 40 days to come up with some decision. The wonderful story, which I always tell, is to demonstrate what kind of a charade that is. I had a colleague who had to cancel the non-binding arbitration. I think it was Ford. And there was no arbitration. But he got a decision denying his claim anyway, because under the decision there was. So it's a charade. It's just a hoop to jump through. 40 days, you're free to file your lawsuit. The implied warranty, of very often overlooked warranty that imposed by law under your state's version of the UCC, usually is contained in Article 2, and the important sections in whatever nomenclature you have is 314 and 316. 314 is the one which says implied warranty of merchantability and gives those 6 or 7 tests, of which only 2 are used. That is the third one, fitness for ordinary purposes, which is a normal one. And the first one, overlooked, which is passing without objection in the trade under the contract description. Comes really handy in cases of cars that would not pass without objection. When they bring it in, trying to trade it in, and the dealer says, we're not taking it, look at Carfax. It says 5 accidents. Yeah, that's not passing without objection in the trade. And I venture to guess in the contract description, it doesn't say, oh, by the way, we're selling your car, which wasn't 5 accidents. Easy case. The reason we like that is because implied warranties are akin to strict liability. They have no requirement of knowledge, no requirement of intent, no scienter, no nothing. It's just a sale of goods by a merchant in the goods of that type, and then the test, whether it's fit for ordinary purposes or pass without objection in the trade. That is a very often overlooked great claim that people should use more often. That's warranties. And then the second part of analysis in every time then when you encounter a car case would be the fraud part. The fraud part would be 2 prongs. One, a jury claim of common law fraud is a misrepresentation of material fact or concealment of material fact, or your state's version of unfair UDAP, unfair deceptive acts and practices. In Illinois, we call it consumer fraud act. Here, for example, in state court, that is a judge claim. If we go to federal court, it's a jury claim. So in federal court, it makes no difference to plead common law fraud because under our Consumer Fraud Act, the elements are relaxed. For example, in our UDAP, there is no reliance by the buyer. So one of the elements of the common law fraud does need to be proven. And I'm not sure about the burden of proof. It may be the same. But in any event, judges are trained to think of the Consumer Fraud Act as fraud light, and therefore it's easier to prove. But you lose a jury if you're in state court, depending on your state UDAP statute. Some of them are better, some of them are worse. But common law fraud is always available. And the claim to look for when you have a common law fraud is a car that was in a prior accident and badly repaired. The reason cars usually are badly repaired is because they go to insurance, and the insurance companies, they don't want to spend much money in terms of repairing the cars. They do it the cheapest way possible, and usually substandard. And usually the cars like that, a coffins on wheel, they will kill you if you get in an accident. The airbags will not come out in the proper sequence. It's bad news. Punitive damages. Send a FOIA request, follow up with the court. That's the second time around. We go back to the beginning, the shorter version. When you have a car case, you have to worry about two general areas of law: warranty and fraud. Warranties, which are a marriage of UCC and MAGMOS, are either express or implied. The standard for breach of warranty is reasonable time or reasonable number of attempts. If they fix things within reasonable time or reasonable number of attempts, no breach. If they take unreasonable time or unreasonable number of attempts, there is a breach. Rule of thumb for unreasonable number of attempts is it has to be 5 or 6 repair receipts. I don't think 3 will do it, especially in this time of day. If there is a persistent problem and we're talking 10 repair receipts or even better 15, well, then that's a very good case. So under MAGMOS, a warranty, express warranty must be in writing. No writing, no warranty. Doesn't count. Whatever they said, disregard it. It has to be a piece of paper that says, promise to repair, particular time, 30 days, 1,000 miles, 50-50 dealer. I mean, anything goes if it's in writing, and if it's a promise to repair, it's an express warranty. Oh, forgot to mention, under MAGMOS, there is an interesting thing. If they give you any kind of express warranty, they may not, as a matter of law, disclaim any implied warranties. It's either all or nothing. So if they give you a express warranty for 3 days, 30 miles, that means the implied warranty is attached to the transaction, and their as is goes out of the window. So you obviously will not have met the 3-day, 30-mile express warranty, but you have the good old implied warranty of merchantability, and if the car is no good, you can sue under that. Remember, though, for implied warranties of merchantability, you have to prove that the defect complained of existed at the time of sale, because under Section 725 of Article 2, the breach of implied warranty occurs at sale. And we prove that by inference, absence of abnormal use, and absence of any reasonable secondary causes. So when you do an implied warranty case, you have to put the client on a stand and get testimony from the client that the client didn't drive the car any weird way, that the client was familiar with how to drive the car, that the client took driver's ed at high school. If it's a stick shift, that the client is familiar how to drive stick shift. Things like that. And the absence reasonable causes. There was no rain. The car was not with open windows. The tree did not fall on the car. Then the argument is there was nothing unusual that happened during the ownership of the car. Therefore, we can infer that the car came with a problem. Hang them. And if they buy your argument, then they hang them and give you money. So that's the implied warranty claim. And so, let's see. Fraud claims. The plum case would be a rebuilt wreck, prior accident, and the worse is rebuilt, the better it is. If it's something that is, because there's that theory of litigation, the reptile theory, I'm sure you heard about it. It basically says that, when it deals with people's safety, those are good cases. And so safety, danger of driving a car that is not properly repaired, that actually probably is also subject to expert testimony. Because things like when they mess up the timing for an airbag, if the airbag comes out too late, it kills you. If it comes out too early, it kills you. It has to come out exactly right so that it catches your head in a proper sequence. And when they repair those cars after accidents, they never do it right because they do it on the cheap. And therefore, those are dangerous instrumentalities. They should not be on the streets. And that point needs to be emphasized. And the way to get that evidence is to send a FOIA request to to whatever office in your state that people complain about. In Illinois, that usually is Attorney General for some reason. They have an office that sends them form letters that say, don't call us, call private lawyer. And then they call me and I see all those letters. And then, you get the names and addresses of those people. And if the complaints they had are similar, then that's admissible evidence to prove pattern and practice. And then the dealer is going to have a lot of problems explaining their pattern of bad behavior. Those are the main claims that you deal with when you get a lemon law case. And now we're going to repeat it for the first time in the most succinct manner possible, just so that you remember. When it comes in your office, any kind of a lemon law car case, you need to worry about two areas of law: warranty and fraud. Warranties under MAGMOS could be express or implied. If it's a new car, it's obviously an express warranty, and you worry about the standard, which is reasonable time for reasonable number of attempts. If you exceed that, then you have a claim for a breach of express warranty against the manufacturer. As I said before, you may not have an implied warranty claim against the manufacturer because of privity requirements in some states, but express warranty you always have. And remember that when you have a claim against the manufacturer for breach of express warranty, you need to worry about the jurisdictional requirement of going to non-binding arbitration. You will find that requirement in the warranty booklet on page 74 or something like that. They usually hide it real good so that you don't find it, to trick you. So you need to go through the whole damn thing and excuse me. Through the whole thing so that you don't get caught filing improper case. That's new cars. Used cars, sometimes express warranties, sometimes implied warranties. Express warranties, it depends on what the warranty says, 30 days or 60 days or whatever. If they don't fix it within reasonable time or reasonable number of attempts, you have a case. Implied warranties, breach of the implied warranty of merchantability, is a fitness for ordinary purposes or passing without objection in a trade under the contract description. You have to worry about proving that the defect existed at the time of sale, and you prove it by putting out evidence that there was an absence of abnormal use and no reasonable secondary causes. In other words, nothing unusual happened with the car that could account for the appearance of that problem. Because engines don't just blow on their own and transmissions don't fail. It means that there was an underlying problem, and it is reasonable to infer that it was there at sale. Of course, the shorter period of time between the sale and the problem, the stronger that inference is. So if you have a couple of months, good case. If you have a couple of years, bad case, don't take it, because the inference is too weak. That's implied warranties. And fraud, common law fraud, or your UDAP. You look for badly damaged cars that are sold without disclosure. Those are plums. Those need to be taken very seriously, not settled early on the cheap, because those are punitive damages cases. And whether or not you're going to be successful in your punitive damages claim depends on whether or not you are able to obtain pattern and practice evidence. Sometimes you can't. It is possible. There are green men on Mars. It is possible that a dealer sold a previously rebuilt wreck only once. Possible, not very likely. I think where smoke, there has to be pattern and practice. And therefore, if there is a rebuilt wreck in your office, more likely than not, it probably is something that they do as a matter of course, because what usually happens is that dealers go to auctions, buy those cars cheap, and sell them not cheap. Just yesterday, I was looking through a case, and I was shocked to see that the auction price was $13,000 and the retail price was $65,000. Something tells me they knew that car was a prior wreck. In fact, I'm pretty sure they knew, because nobody buys a car for $13,000 and sells it for $65,000. That is not the fair market price. There is a reason why they sell it so cheap, and that's kind of evidence that you would present to a judge and or a jury and ask for substantial punitive damages to punish the defendant within the guidelines established by the Supreme Court, which is, don't ask for more than 10 times of actual damages, because that raises constitutional questions of due process. But hey, if you have a $20,000 car and your diminished value is $10,000, $100,000 10 times sounds pretty good to me.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Draw. D-R-A-W. Draw.
Now, we have 12 minutes left, and I did what I intended to do, which is to repeat the same thing in a shorter and shorter version 4 times, because what I want you to remember, without referring to the little outline that I provided, is most important concepts: reasonable time, reasonable number of attempts as a standard for breach. The 2 main areas of law which you look at when you get a car case, which is warranty and fraud, and the distinctions between express warranties and implied warranties, and most importantly, if you do an implied warranty, how to prove that the problem existed at the time of sale. That's with respect to implied warranties. And alarm, 10-point alarm, to remember that in cases of express warranties against manufacturer, you gotta go to the non-binding arbitration because it's a jurisdictional requirement. That hopefully that is it in a nutshell, and I hope that you will remember at least some of them. Now, I I understand that there are questions, and I welcome questions, and there is something I'm supposed to click, and I will attempt to do that. Okay. So here's a question number 1. If a warranty issue and reasonableness of a repair scenario, is there a right to cure from seller, and how many opportunities must you give to get it right when safety is involved? If I have an issue and I don't trust their ability to fix, do I jeopardize my right to pursue a claim by not giving additional opportunities to cure? Very, very good question. I think that the answer is you have to give them a reasonable opportunity to repair, which is cure. But as everything in law, it's a sliding scale, it's a continuum. When it comes to safety, the opportunities that you have to give them are considerably less than when it's a bad radio. Plus, of course, my answer is let them fix it, because they're not going to. The problem, of course, is the client needs to drive the car. Ideally, the client should not drive a car. If they repair it badly, that actually is an aggravating factor, because that the argument would be, we gave them an opportunity to repair this coffin on wheels, and they pretended to repair it. They didn't really repair it. They lied to us about repairing it. They put my client in jeopardy again. So let them do it. They won't be able to do it. Most of those things are unrepairable. Putting chewing gum, putting together two parts is not going to repair it, because to repair it usually costs more than the fair market value of the car. So I'm not worried about them repairing it after they quote unquote repair it. If you have a mechanical expert look at it, chances are he's going to say that repair was worse than the initial problem. Okay, another one. Oh, I had two. Please recap. Well, I think I recapped 4 times. Do you really want number 5? Okay, I can do it in under 1 minute. Car case, implied warranty or fraud. Warranties, express, implied. With express, worry about non-binding arbitration. With implied, worry about proving that the defect existed at the time of sale. Standard of proof, reasonable time, reasonable number of attempts. Damages, diminished value. Fraud, common law fraud, UDAP. Look for rebuilt wrecks that are dangerous to drive. The key to the case is to get pattern and practice evidence. You get it via FOIA request or going to local courthouse and finding out whether or not the dealer was accused of similar conduct and lawsuits were filed, or the BBB, or any kind of organization where consumers in their, post their high school civics class think that they're going to get anything by, raising, or, for example, internet complaints. Sometimes they post negative reviews. The problem, of course, is to get their names and addresses, which is sometimes impossible. That is a recap in under 1 minute. I hope you remember it. Any more questions? By all means, put them in. Oh, here's another one. Now repeat it backwards. Just kidding. I actually can do it. It's fraud and warranty. I will repeat it once again, but not backwards. Reasonable time, a reasonable number of attempts. I once delivered the lecture to our local JAG officer corps at Great Lakes, where they always call me because I'm the resource, and they're JAG officers who are used to getting drunk sailors out of, out of a slam or after a bar fight, they wanted to know about cars, because one of the biggest scams the dealers do is with respect to service members, because there's some military regulation that they can't not pay their loans. It's guaranteed. It's like deducted from their pay. So they take advantage of the young guys really badly. And so after my lecture, a month later, during our monthly meeting, I saw one of the JAG people, and he came to me and said, I remember reasonable time, a reasonable number of attempts. And I said, well, okay, my driving to Great Lakes was not in vain, because now you know. Reasonable time, reasonable number of attempts, that is the standard. And I see that we have 5 minutes left. I do not want to recap it again, because I think everything that I wanted to recap, I already did. If anybody has any questions, by all means do. Otherwise, we thank you for coming. And, if you have any questions, if you might have any questions, after we log out, I always invite people to contact me. It's in my webpage, and I will repeat it again here. The easiest way to get hold of me for any kind of car issue is by my email, which is chicagolemonlaw@gmail.com. When I established this email address, I figured I will never have to spell it for anyone. I was wrong. A couple of clients asked me how to spell lemon, and one guy about half a year ago asked me how to spell Chicago, although he was a foreigner. I did not blame him for that. When I was fresh off the boat in Kirksville, Missouri, I didn't know how to spell St. Louis, because there's an OU there, and I did not know. So I understood where he was coming from. But normally people have no problem remembering it or spelling it, or more importantly, remembering it, because I do lemon law, and most of it I do in Chicago. Therefore, chicagolemonlaw@gmail.com. We also have for people who do it full time and sign in blood that they will not represent evil car dealers, we have listservs that provide for discussion of those issues and asking questions and stuff like that. And so if anybody wants to commit to that and do consumer law without representing dealers, because we don't want our trade secrets to be disclosed to the dark side, do let me know, and we'll set you up. chicagolemonlaw@gmail.com. I would be more than happy to answer any questions or discuss any problem, because hey, talking beats working. I would rather put what's left of my brain after all that vodka damage to use, rather than respond to standard interrogatories, which is the biggest pain. But it's a fun area to do, primarily because your defendants are so just blatantly evil, not in warranty cases, but certainly in fraud cases. And they have no shame, and they do not think that they do anything wrong, because that's their business model. And so when you call them on that, they are shocked that somebody could question their motives or their business practices. So if you have a warranty or fraud case, warranties is express or implied, or fraud, which involves a badly repaired car, which is dangerous to drive, that is the time to nail them, and they deserve it. So with that, I think we are out of time. Thank you for coming. Reasonable time, reasonable number of attempts. If you don't remember anything out of this hour, please remember that, because that will give you an idea whether the case is worth it or not. Miss Carol-Ann, I think I am justified in turning it over to you. Can you hear me?